Do complex legal issues hold you back? Let's get energized and bring clarity to your top legal questions. This is Law Talk with the Flock by Goosmann Law Firm.
Hello, I'm your host, Jeana Goosmann, a CEO, lawyer, author, and woman business owner, here to help navigate you through the law, your business, and life as a leader. For today's episode, I have with me attorney Matt Dunning. Matthew is an employment law attorney here at the Goosmann Law Firm, and today we're going to talk about terminating employees. How about that for a topic? Matt, could you start out by introducing yourself to our listeners?
Sure. Thank you for having me on. And yes, my name is Matt Dunning. I've been practicing attorney for almost 30 years and have always worked in the area of employment law, even started in law school with studying those courses, and have had a lot of experience counseling primarily employers, handling litigation or supporting litigation for wrongful terminations, discrimination claims, and that sort of thing. I will work with employers on handbooks, policies, employment agreements, and terminations. So one of the areas I really like to work in is non-compete agreements, employment agreements with restrictive covenants such as non-competes, non-solicitation, or confidential information dealing with trade secrets, and helping employers manage the risk of someone leaving and then becoming unfairly competing with the company. I'll also work with individuals on those issues in limited circumstances, and sometimes on employment agreements or severance agreements for individuals in certain situations.
Excellent. Well, certainly a wealth of experience and a really strong background to talk about this. And I know that for an employer or a manager at a company, anytime that you have to terminate an employee, it's a very stressful time for them. What are some common mistakes that you have seen over your years of practice when it comes to terminations?
Yeah, and it is stressful for everyone. I think, it puts everything under the microscope as far as the human resources, systems, management skills. Everything comes to a bit of a boil potentially, and people want to recruit and retain and not have to worry about terminating or making changes if they don't have to, and so it does lead to that stress and that uncertainty. So the mistakes that can happen aren't always at the time of termination. There's the development of handbook and policies are the foundation for the termination, and that has to be done on a proactive basis. We frequently get a handbook project when someone wishes they had a policy that would have made their termination process more simple. Things like a good job description can also help. If you have a strong job description that establishes the qualifications for the job and the duties that are required, that is a key piece of evidence. If you do have a claim from someone who is saying they were disabled or regarded as disabled, courts will defer to a job description absent rebuttable evidence from the employee that didn't apply. So it's important to have those tools in place. It's good to have those tools in place whether there's a termination or not, obviously, but it's at that point of termination when everything is kind of put to the test. One of the things that I've observed is at the time of termination, it's difficult at times to let someone stay on board, let someone stay in the office environment or in the work environment after they've been terminated. That can lead to a lot of different problems. So you need to have a plan in place before you do that. And if you're going to let someone finish up some projects, for instance, maybe their access to resources would be limited to what they absolutely need versus all of the information that they would normally have access to in their day-to-day work. Obviously, in Nebraska, the law requires that employers pay out any compensation, any wages that are due to the employee. I recommend that just as a compliance matter, of course, but also you're not looking to make the employee angry. You're not looking to give the employee a reason to file a discrimination claim or file a retaliation claim, or even file a complaint against the employer with an agency that regulates it, or an OSHA complaint. So try to, it is stressful. It is, emotions can run high, obviously. But my advice is always to try to make it as smooth as possible and not poke the bear, I guess, to try to avoid problems from resulting.
So certainly, like, being respectful is always number one all the time at work. And quite frankly, I think in life in general is to respect other people and treat them with respect.
It's professional at any level of employment. It doesn't matter, from the CEO to the CNA in the healthcare environment. That's everyone deserves to be treated with respect and professionally. You're looking for problems when you aren't treating people respectfully. Now maybe those problems already exist, but they may fade away. But some folks are just they're gonna find something, and some folks have a legitimate complaint. There are certainly situations where things are mishandled and need to be addressed, corrected, handled differently.
I've always thought it's a good idea too to make sure you have a witness with you if you're going to terminate another person. What are your thoughts on that, Matt?
Yeah, definitely. Now, I'm not a fan of recording termination meetings or things like that, but I do recommend always having someone else, whether it's over the phone or in person. You want to have someone else because you don't know what that reaction is going to be. I've had an employer where there was a violent reaction. That's very rare. But certainly, if those accusations are going to start flying at a termination meeting, you want to have two people there to A, help control the situation, but B, then also document what's happening, and you've got two witnesses instead of one, and it's not a she said situation that can be more complicated. If things like that happen, you certainly need to document and put that as part of the personnel file. One thing with employers, sometimes looking for a fight, and I see it both ways, but an employer will have a terrible performing employee, but they're just a bad performer. Then so they make a termination. Then the employee files for unemployment compensation. Well, if the employer denies that or fights that, that really opens up a front of controversy and dispute. And unless the employee has engaged in pretty egregious misconduct, they're going to get their benefits. So there's not a lot of percentage in fighting those. Now, certainly in some situations you do want to, but I guess the point is to have a conversation about it, whether it's internal within a human resources environment or senior management, whatever it is, or with a lawyer to determine, is this really worth the effort, or is there an opportunity here to just let the person go quietly into that dark night? So
That's a really good point. And I think having a conversation with an attorney such as yourself before you make a termination sometimes is really prudent for an employer to do, especially the higher level employees. And I know there have been several instances where I've been contacted to help companies when they're going to terminate even their CEO. If a board has decided they're going to let the CEO go, I know I've been a part of a handful of those situations, even in a couple of them, we had to have security present, that we just anticipated that this could be volatile, and in closely held companies or people who have been around a long time and kind of become like family, that can become a real issue.
yeah, I mean, there's familiarity and no, it's pretty rare that someone says, yeah, I think you're right, I should be terminated. They don't, they may not be disagreeable about it, but they're not going to be, agreeable. So that reaction does need to be anticipated. It does go to personality issues, the history of the communication. I don't think a termination or even just a bad performance appraisal should come out of the clear blue sky for an employee. You want to have these conversations ahead of time. They may be faced with some unwelcome news or maybe some surprising news at the level of where it is, but it shouldn't be the first news that they've heard of it. And that you can just avoid a lot of problems. And that goes back to management skills and having those policies in place. But
Yeah. And I know a few times too in circumstances where some of our clients have actually hired us to come in and do the terminations as the attorneys, where for whatever reason they were just too uncomfortable and couldn't do it themselves. So I know I felt like in the movie George Clooney, Up in the Air, when all they did was fly around the country and fire people. I'm like, I'm glad that's not my full-time job, but
yeah, he's never home. He's just
exactly. Right. All he did was he was the axe man. He flew around the country and did that. What else do you think? What documents should they have in place before they plan to terminate someone?
Well, ideally, you've got some performance evaluations that reflect some problems that have already been documented and observed. Cases where, when everything is wine and roses with the employee, your supervisors, your managers may give them some glowing remarks and some. They may want to help them get, the promotion or the salary increase, and so they may have some things that are not necessarily accurate in the performance evaluation. Maybe they want to be supportive and they don't want to be negative. Well, then if things come to a head and there's problems that are occurring, you are stuck with that. You're stuck with those appraisals and evaluations. So it's good to have those in place, have them be accurate. If there's a history of misconduct or poor performance to the point where you're disciplining the employee, you've got prior warnings, a verbal warning that's written and documented, written warnings. One mistake employers will make is to think that they are required to go through a lockstep progression of discipline. It's good to have a progressive disciplinary policy, but your policy also needs to have the flexibility to go directly to termination or directly to a higher level of discipline than when the circumstances are appropriate.
So when the employee steals from the company, you can just terminate them. You don't have to go through a written warning.
That's a termination, and that's also misconduct on your unemployment claim. Yeah, and there are obviously those circumstances, the extremes. Employment is, we spend a third of our lives, working, and it's very personal to people. And sometimes I refer to it as almost like a business divorce. It's got a lot more structure than a personal relationship, obviously, or hopefully it has that structure with policies and agreements and et cetera. But people get very upset, and understandably so. It's a very personal thing, and it's rare that people think that they're entirely in the wrong. So there's going to be some blame shifting, and it gets back to that stressful moment.
I want to go back for a minute and just talk about documentation. So I think, especially in the professional corporate context, it's written warnings and some of that sort of stuff, especially if you're dealing with other professionals and high executives. That you don't tend to see that type of documentation as much as a lot of times I'll tell my clients, well, just email yourself or email HR and make sure that you're creating a record of what happened and a kind of a timeline for how it's progressing, so that it's not just at the very end where all of a sudden now we need to write this all up, but it's sort of a progression. What are your thoughts on the email yourself or email HR approach?
Well, either way, if the manager thinks that they are, able to handle the situation and just keep it to employee manager level, I think that's, appropriate at the beginning. But there are times when HR is going to be very valuable. There's a lot of times when HR is going to be very valuable, and one of those would be if HR can come in and kind of be the intermediary between. If there's some training that's required, they can identify what those training requirements might be. If they can, if there's delegation of duties that are at issue, they can help sort that out. And so it's, one manager to another manager is not going to be as effective on that, and it's going to be more case by case versus HR coming in. The value of HR is, consistency. So when you have someone who's requesting a leave of absence because of a medical condition, all those requests should go through your HR personnel, because managers are going to make wrong decisions, or they're going to make decisions that are overly generous or whatever it might be, or even just inconsistent. So it provides the certainty that employees really value. Talking about documentation, you may think you don't have any documentation, but one of the things I've done is talk to the managers, talk to the HR personnel, and you say, okay, well, what were the emails? And then I'll say, well, yeah, I did write an email, and I did tell them they didn't do the right thing on XYZ project, or calendar entries, or phone records. Here's a 45-minute phone call between the supervisor and their employee, and they weren't talking about the weather. They were talking about a problem, and they were talking, and so that kind of thing triggers memories, and then document it right then.
Certainly there is a lot to think about when it comes to terminations, and thanks for starting the dialogue with me today, Matt, and being a guest on the podcast. I want all of our listeners to go have a great day and make it worth it.
Yeah, thank you, Jeana. Really appreciate it.
Thanks for joining us for Law Talk with the Flock by Goosmann Law Firm. We hope you feel energized and ready to soar past your goals. Become a Flock fan and subscribe to our podcast for weekly episodes. Learn more at goosmannlaw.com.